Hey, I've got a couple of questions about writing assignment one, so I thought I would verbally give you a little more instruction. So if you take a look at writing assignment one, you'll see that it's structured really similarly to the theft example we started in class yesterday. Yesterday, we had a small fact pattern. We had the question as to whether or not a statute applied, and we started that analysis, and we just were verbally talking through it. When we finish that analysis, we then apply the two cases that were in the middle of that handout to determine to our facts. So we apply the law to the facts. We do that with the statute and we do that with the two cases. And if you look at that, you can put together an IRAC formatted explanation. And so you start out with the issue in the theft example being, is this person guilty? Can we convict him of theft or theft or possession of mislaid or stolen property? And we can then do an analysis, and our analysis would be threefold under the information we have. First, we would write as to whether or not his conduct fits under the statute. Now, that's exactly what we did in class. We all kind of brainstormed and we talked about little facts of his that made it look like it would fit the statute and he would be convicted, and then other facts, like the fact that he put it in his pocket, maybe that shows that he's going to try to give it back. All those different facts that we looked at, the ones that could go either way, are analysis, and they are whether or not that statute fits what our guy did. Okay. If we had had more time, we would have gone on to look at those two cases. And we did look at one. Briefly, there was one case about a woman on a train and she pocketed, what was it, a watch, I think. And then what we knew about her, that's the very first case. We didn't get to it significantly in both classes, but determine that case, we can apply that to our situation and determine what it says about whether our guy had the intent to steal the locket. So that's what you're doing. You're taking the cases that were listed in the writing assignment one. You got a fact situation, and you got cases, but they were listed by citation. In the theft example, they were just created, and you saw the text of them in the actual handout. But in the writing assignment, they're giving you cites. So you have to look up those cases and read what they say and then apply them to the facts that we have in our factual situation. When we use the IRAC format, that's just a way that we organize start to finish a memo or a brief. We say what the issue is. We say the rule that we relied on. And so if you look at those four cases and one of them doesn't apply at all, we don't put that in our rules section. Then we go to an analysis or an application. That's where we apply the law to the facts. So you look at the facts of writing assignment one and you apply the cases that you were given. You don't need to do any additional research. The only law that you need to apply is the law that is given to you in the problem. So it's what we call a closed memo. This is just the start of it. So you're just doing just this. You're only given the four cases. That's all you need to look at. And then you come to a conclusion. So in the theft example, you would write a conclusion as to whether, yes, you felt it was most likely that the statute would apply and he could be convicted of theft, or no, most likely we cannot prove that he had the intent to steal the locket. IRAC is a structure only. Issue, law, application, applying the law to the facts, and then our conclusion. If you're trying to determine what kind of tone you use, it's predictive. You're not trying to persuade a judge of anything. You're trying to say, hey, let's take the theft example. You know what? We are the defense firm. He is our client. I'm looking at the law, and under the law, he looks pretty guilty. So maybe the senior attorney would use that to determine that he should take a plea. So it is designed to predict what the law is so that we can give the best legal advice we have. It's not designed to persuade. So if it were designed to persuade and we were the defense attorney, we would be saying, Judge, this is a motion to dismiss, or this is a motion, maybe it's helping me prepare my closing statement to a jury, closing argument to a jury. now I'm going to have a different tone. But in this particular writing assignment, it is literally just the best guess or the best analysis of applying the law to the facts is that this is what should happen, most likely. You do not take a side. You are looking at all of the cases applied to all of our facts and determining what is most likely to happen in court. It does not matter. As I said yesterday, it is, as long as you support through looking at the facts and applying the cases, as long as you support your conclusion, it matters a whole lot less which conclusion you come to. So in the theft example, we had facts on both sides, both facts that showed his intent was to steal the locket and facts that showed his intent was not, or that we could not prove that it was to steal the locket. It matters a whole lot more how in depth you look at the cases and say, well, look, let's compare this to the case of the woman on the train. In our situation, in her situation, this is just an example. She actually knew who the identifiable person was who lost the locket. She knew likely what business she was in from the trade magazine she was reading. And she knew perhaps where we could find her at work because of where she got off on the train. We can't say the same about our particular client in the theft example. He didn't see the person who dropped the locket. All he knows is that the locket was dropped at the YWCA softball field. So you can apply that and you can say, for example, this shows that we do not have proof of the intent because we did not have a reasonably identifiable person under the statute to link the locket to. Or you can say it's reasonable that in this situation, we have a group of people, and in fact, we might have even clearer evidence of who the person is who lost the locket because of the initials on the locket, and he could go to the YMCA and figure it out. You could take either conclusion as reasonable as long as you support it with the cases that you have in the assignment. So you do not have to be pro locket finder or pro locket owner. You just have to look at the cases, apply them to the facts, and come up with your best conclusion as to what is most likely to happen. So as far as tone is concerned, that's what you do. If you look at writing assignment 1, there's also a header. So this assignment was given to you as a law clerk from a partner or an associate in the firm. So the to and the from reflect that. The number at the top is an internal docket number, so there is no need to look at how to cite that. That is just the number that the law firm assigned to the case file so that they can find it later. There's no Blue Book convention on it because it's whatever the law firm itself picked to identify its own clients. Sometimes it's a year, sometimes it's the number of the client, sometimes it's based on their last name. You don't need to worry about it. It's just the number that the law firm has assigned to this individual file. It isn't a docket number or a case number. So you have a to, from, regarding, and a date. You're going to change the to and the from and the date, obviously, because it's your response, but you can use that same header. Then the formatting is going to start with, essentially, in more formal language, here's what I've been asked to do. And you repeat the question. That's your issue. I have been asked to provide analysis of this situation in this way. And you kind of restate the question that was given to you in the writing assignment. Then you say, these are the 4 cases or 3 cases or 2, whatever you read, the cases that were given to you, because your attorney said, here's what's happening. Here's the law I want you to look at. And so the rules are going to just be the rules that come out of those cases or the cases themselves. Then your analysis section is you've read the cases and now you're going to apply those cases and whatever statutory authority is in the problem to the facts. We started that in class yesterday when we were looking at the facts in detail relative to the locket finder's intent and the reasonableness of the how we knew the person who owned it was. That is going to be a fairly detailed process. Remember how detailed we got into the facts yesterday? We looked at them in application to the statute because we looked at how many of them covered the 2 parts of the statute, whether we could reasonably ascertain the owner and what his intent was. There might be more in the cases that you read as to how we determine that intent or how we determine the reasonableness of finding the owner. And so you take those cases and sort of expand on them and use them to figure out what the court's going to do with our guy in writing assignment 1. Okay. IRAC is just an organizational format. That's all it is. We're going to tell you what the issue is. We'll tell you what law we relied on, and then we'll apply the law to the facts and come up with a conclusion. That's all IRAC is. And whether you call it IRAC, whether you use different headers, it doesn't matter. You just have to get used to, here's the question, here's the law, here's me applying the facts to the law, and here's the conclusion. That's all IRAC is designed to ever give you. It's a format, and it keeps you organized, applying law to the facts. That's all it does. You'll have a different sort of internal organization of the analysis portion. You might, in our theft example, you might take a common sense look at the statute first and then apply the cases just from an organizational standpoint. Sometimes you can look at a case and you can say, hey, this case is directly on point. I'm going to at least start with it. I may not even have to analyze much more because this case says flat out he's guilty or whatever it says. That happens in real life more than it's going to happen in an assignment, because in an assignment it's designed to give you multiple things to argue. So it's designed to be it's designed so that you can come to any conclusion that makes sense to you and get points for supporting it. There's enough in the problem to give you stuff on one side and on the other. So that's your goal. Your goal is to apply the law in writing assignment 1 to the facts of writing assignment 1 and then come up with a conclusion. So if you still have questions after this video, send me an email. I am not leaving until Saturday morning, so you have plenty of time to get questions answered before then. You're going to do great.